This presentation will focus on the very risky claims that are being filed in Israel by liquidators and special managers of an insolvent company. One of the main assets of a company which becomes insolvent is the D&O liability policy. The liquidator will make every effort to bring a claim against the D&Os and their insurers in order to recover from the D&O policy. Almost every insolvent company which has a D&O liability policy will therefore be at risk for a liquidator's claim. The first action which will be taken by the liquidator or the special manager in order to try and catch the D&O policy will be to give a very general notice to the D&O insurer concerning his intention to bring a claim against the D&Os. The notice will usually be given immediately after the appointment of the liquidator and long before he can actually specify wrongful acts of the D&Os which led to the collapse of the company. The liquidator will obtain the insolvency court's order to summon the D&Os for investigation, in which he will try to substantiate wrongful acts of the D&Os which led to the collapse of the company. The D&Os on their part will have the right to be represented by an attorney in these investigations, and the legal representations, as we have many years of experience on that, we can say that it is very important in order to protect the insured's interests. The next step after the investigation stage is concluded, the liquidator or the special manager will usually file a claim against the D&Os and sometimes against the D&O insurers in view of their direct privity of the liquidator against the insurers according to the insurance contract law. The liquidator or the special manager will file this claim in many cases to the insolvency court and not as a regular claim in an attempt to handle short proceedings against the directors and officers or against the insurer without having to pay court fees while having the sympathy of the insolvency court towards their claim. The D&Os will make every effort to handle this claim as regular proceedings in order to protect their rights and interests. The cause of action which we see in most of these cases will be based on the breach of duty of care towards the company or the breach of duty of trust towards the company by the D&Os, which led, according to the special manager, to the collapse of the company. Two examples that I would like to give you for claims that were filed by special managers of a company that became insolvent is the first one is the Feuchtwanger matter, a claim filed by the special manager of the company for the amount of 250 million shekel. The claim was filed against 7 D&Os of the company who was appointed 7 days before the company collapsed. And the argument of the special manager was that they took upon themselves to approve a very risky transactions which led at the end of the day to the collapse of the company. The claim was settled at the end of the day by settlement of $8 million. Another example of liquidator's claim is the claim which was brought by the liquidator of TLV against Migdal Insurance Company. Migdal, represented by Levitan Sharon, was the D&O insurers of the Carmel Holdings Group. Now what happened there is that Carmel held 100% of the shares of TLV, which in turn held 100% of the shares of Gaia International. Gaia was established in Turkey as a joint venture company together with a local Turkish company for the purpose of manufacturing and marketing carpets in Turkey. At some stage, financial irregularities were found in Gaia, which according to the liquidator led at the end of the day to the collapse of Gaia and its parent company, TLV, and therefore the banks of Gaia realized a $10 million bank guarantee which was given by TLV for the operation of Gaia. Therefore, the special manager of TLV brought a claim against Migdal as the D&O insurer for the full policy limit which was there $4.5 million, alleging that the wrongful acts of the D&Os led to the collapse of the group. The D&Os themselves were not adjoined as defendants to this claim, which is very unusual. The District Court of Tel Aviv decided to dismiss this claim after handling a full trial. The court accepted Levitan Sharon's argument that plaintiff failed to prove the alleged financial irregularities in Gaia and their causal connection to the collapse of the group. We have been able to show the court that other factors, such as the substantial drop of the rate of exchange of the Turkish lira and the dollar, led to the collapse of Gaia, which has nothing to do with the wrongful acts of the D&Os. The court also accepted our position that the notification which was given by the special manager to Migdal, given within the policy period, was very general, as it only indicated that the company entered into financial difficulties without specifying the specific wrongful acts of the D&Os which are being attributed by the special managers to the directors and officers. This is contrary to the D&O provisions of the policy. The court also accepted the position that the special manager has indeed a direct privity against the D&O insurer. However, he should have joined the D&Os as defendants to this claim, which he didn't. And the policy requires that a claim will be made against the directors and officers themselves, and it is not enough to file the claim against the D&O insurer. The court also accepted the interpretation which was given by Migdal to the IVI exclusion, according to which a claim which is filed by the special manager is not covered under the policy if the claim is being assisted by the policyholder. In this case, the policyholder, Carmel Holdings, assisted the special manager in this claim, also financed it, and had a clear interest with the results thereof. Another creative argument which was made by the special manager was that Carmel Holdings, as the policyholder, had to reach a creditors agreement with its bondholders due to the collapse of its subsidiaries, and that within this agreement, the shareholders of Carmel Holdings, who were also the D&Os of the subsidiaries, contributed significant amounts towards the creditors agreement. In turn, the bondholders agreed to exempt these D&Os from the claims against them. It was argued that the payment which was made by these D&Os mitigated the potential risk of potential claims against them and against their insurers, and therefore the D&O insurer, Migdal, should pay these amounts to the D&Os. The court accepted Migdal's position that the contribution was made by the D&Os in their capacity as shareholders in order to protect their interest, and that no threat or claim was made against them, and no prior approval was given by Migdal. Therefore, Migdal had no duty to reimburse the D&Os for any such contribution. An appeal was filed to the Supreme Court, which recently decided to withdraw the appeal, and this matter was concluded with no payment by Migdal. Obviously, there are many cases for claims brought by liquidators and special managers for significant amounts in which settlements are being achieved with the D&O insurers, considering the risks involved obviously in each claim.